Morning, everyone. I'm Judge Corey Amanda Cawthon, and this is First Appearance Court. Today, I will let you know if I have determined probable cause, and we will talk about release conditions. Remember that today is not your trial date, so I encourage you to speak with your attorney before speaking on the record, because everything that we say today is being recorded and can be used against you at a later date. If you are represented by the Public Defender's Office, attorneys from the Public Defender's Office are present both here with me in court and at the main jail. For those of you that are at other facilities, these attorneys are available to you by phone. For those of you who are represented by private counsel, your attorneys come to the courtroom and are able to address your case from here. If your attorney is not present in the courtroom when I call your case, you can let me know and we will see how we can facilitate you through that process. However, I ask you not to tell me that you have private counsel unless you or your family have retained an attorney for this specific arrest. You also need to know that in the courtroom with me, I have attorneys from the State Attorney's Office, as well as representatives from Confinement Status, Pretrial Supervision, and the Clerk of Courts. These persons are here to facilitate the morning session and to provide any additional information if needed. For those of you that are here for first appearances for misdemeanors and municipal ordinance matters, you may be able to resolve your case here at first appearances, but that will be dependent on what is going on with you and your case personally. If it is a felony or violation of probation matter where the judge has already placed a no bond hold, that cannot be changed or resolved here at first appearances. After today, your case will be assigned to a specific division judge, and moving forward, any pretrial motions and subsequent trial will be heard before the division judge. Before we get started, let me just ask Mr. Reedy, has the jail requested that anyone be taken out of turn?
Yes, they have, Your Honor. We have 4.
Okay, will you just give me those?
Yes, on page 8, we have Mr. Smith.
Okay.
On page 16, we have Mr. Tirado.
Okay.
On page 17, we have Mr. Rios.
All right.
And page 18, we have Mr. McLean.
All right. Let me just pull those up. Okay. So we'll start off with Shannon Smith.
Good morning, Judge. Who's approaching?
Good morning. Thank you, Mr. Romero. All right. Good morning, Mr. Smith.
Morning.
You're before the court on a misdemeanor capias. I do find probable cause. The bond is currently set in the amount of $500. And Mr. Smith, you do have a hearing before your division judge on the 9th.
Judge, it's being Mr. Smith earlier today. He wishes to resolve this matter. We wanted to know if the state had a plea offer for him.
Okay.
Yes, Your Honor. The documented offer from the assigned ASA is a withhold court cost.
Judge, and speaking Mr. Smith, he wishes to accept the state's offer.
Okay, thank you. Mr. Smith, will you raise your right hand, please? Do you swear or affirm to tell the truth?
I do.
Okay, thank you. You can put your hand down. Mr. Smith, do you understand everything that's been discussed here today?
Yes, I do.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need more time to speak with your attorney?
Yes. One moment, please.
Okay.
Judge, he asked the question and we can proceed.
Okay. All right. Mr. Smith, do you need any more time to speak with your attorney?
No.
Okay. All right. Do you understand that you have the right to a trial, but you are waiving that right by accepting a plea today?
Yes, I waive it.
Okay. Have you ever been treated for mental or emotional illness?
No.
Do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
I understand, yes.
Okay. And what plea do you wish to enter, guilty or no contest?
No contest.
All right. Thank you. I accept your plea and find that it is freely and voluntarily given. The sentence in this case will be a withhold of adjudication and court costs. Usually I do 6 months. Yes, ma'am. All right. Mr. Reedy, Torado, the first name is Ricky, correct?
I'm sorry, Judge?
For Torado, it's Ricky Torado?
Yes, ma'am.
Okay.
And he's gonna be requiring a Spanish interpreter, Judge.
Okay.
Well, we have one on the way.
All right, I'll put him to the side until we get our interpreter. Okay. Where'd the other one go? Rios? Okay, Gino Rios.
Mr. Rios is approaching, Judge. He's here at Maine.
Thank you.
Judge, after speaking to him, me and my colleague both asked him. He does not wish to have the help of the public defender. He wishes to represent himself pro se.
Okay, thank you. All right, Mr. Rios. There you go. Mr. Rios, you understand that you are entitled to have an attorney represent you for this hearing today?
Yes,
Okay, and you're refusing the services of the public defender at this time?
yes,
Okay, all right. Let me go ahead and read the charges. All right, Mr. Rios, you're before the court on count 1, carrying a concealed firearm. Count 2, grand theft of a firearm. Count 3, burglary of a dwelling, structure, or conveyance armed. Counts 4, 5, and 6 are each for felony probation violations which have no bond holds at this time. I do find probable cause, and I will hear from the state if they wish to make arguments as to bond.
Thank you, Your Honor. On count 3, the
Yes.
armed burglary,
Yes.
the state would be seeking a finding of proof evident or presumption great for first appearance purposes. And ask that Mr. Rios be held no bond at this time, and that he be allowed to seek an Arthur hearing in front of his assigned judge. Just relying upon the affidavit noting the incident was captured on video surveillance and that Mr. Rios made a post-Miranda confession. Also, I apologize, noting the stolen firearm
Yes.
was recovered from his vehicle where he told law enforcement it could be located.
Branch and Skipper.
Okay, at this time, as to count 3, the court will exercise its discretion and make a preliminary finding of proof evident presumption great. This is without prejudice for Mr. Rios to have a hearing before his division judge to address any further issues. With that being said, the remaining counts 4, 5, and 6 all have no bond holds. And counts 1 and 2, I'm going to leave the standard bonds in place.
Our Spanish interpreter is present, Judge.
Thank you.
Judge, there's 3 individuals that are going to be requiring the services of the Spanish interpreter. Two
Okay.
of them are located on page 6 of the court's docket. That would be Mr. Carrillo and Mr. Jacome Fajardo. And the third individual is the person you've already called that's on recall on page 16, Mr. Torado.
Okay, before I call Mr. Torado, let me go ahead and take the other case that the jail had requested to take out of turn.
Yes, Judge.
That's going to be David McLean.
He's approaching, Judge. Come on up,
Thank
Mr.
you.
McQueen.
I believe he has private counsel.
So your father did hire him. Okay. He did? Yep.
Matthew Glassman texted me about Mr. McLean yesterday.
Okay, is Mr. Glassman coming?
I texted him letting him know the jail wanted to call him out of turn. I haven't
Okay,
heard back yet.
well then, I'm just going to I'll have Mr. McLean wait a few minutes until Mr. Glassman.
No problem, Judge.
All right, so we'll go ahead and do the interpreter cases. All right. Carrillo. Okay, so where's our interpreter? Do we have an interpreter? So. Good morning. Okay, will you raise your right hand for me? Do you swear or affirm to interpret from Spanish to English and English to Spanish to the best of your ability?
I do. Esteban Rojas.
Thank you, Mr. Rojas. Okay, so first up will be Ricky Tirado.
Please approach the judge.
Thank you. Okay, good morning,
Carrillo,
Mr. Tirado. I'm sorry?
Mr. Rubidio Carrillo.
Oh, I had Ricky Tirado was gonna be first.
Oh, Tirado was the gentleman, I believe, that has Mr. Glassman.
No.
No, that was McLean.
Oh, I'm sorry, Judge. Come on up, Mr. Tirado. I apologize, Judge.
That's all right. Okay, good morning, Mr. Tirado.
Buenos días, señor Torrado.
You're before the court on count 1, possession of heroin, count 2, resisting an officer, obstructing without violence.
Usted está ante esta corte por el primer cargo de... could you repeat the first charge, Your Honor?
It was possession of heroin.
Posesión de heroína y el segundo cargo es resistirse al arresto sin violencia.
Count 3 is a felony probation violation
El
with a no
tercer
bond
cargo
hold.
es una violación de probatoria en grado de felonía
With a no bond hold.
para la cual no hay fianza posible.
And count 4 is also a probation violation.
El
and a
cuarto
felony,
cargo también es una violación de probatoria sin fianza posible
which is a felony case with a no bond hold as well.
en grado de felonía.
I do find probable cause,
Considero que existen indicios probables.
and I will hear from the parties if they wish to make argument.
Escucharé a las partes si desean presentar argumentos.
Nothing from the state.
Sure.
De parte de la
Considering
Fiscalía,
a no
nada.
bond hold,
Yes.
nothing to add, Judge, from the
Su
defense.
señoría, tomando en cuenta el hecho de que no hay fianza posible, entonces no tenemos nada que agregar.
All right, I'm going to leave the standard bond in place on count 1,
Bien, voy a dejar en pie la fianza de rigor para el primer cargo
and Mr. Tirado will have a hearing before his division judge on the 9th.
y el señor Torrado tendrá que comparecer ante el juez de su división el 9.
Thank you.
Gracias.
Okay, and Rubidio Carrillo will be next.
Rubidio
Señor
Carrillo.
Carrillo?
All right, good morning, Mr. Carrillo.
Buenos días, señor Carrillo.
You're before the court on count 1, domestic battery by strangulation.
Usted se encuentra ante esta corte para un primer cargo de lesiones domésticas por estrangulamiento.
I do find probable cause,
Considero que existen indicios probables
and I will hear from the parties as to bond.
y escucharé a las partes en cuanto a la fianza.
Your Honor, I see that Mr. Carrillo has no criminal history.
Su señoría, veo que el señor Carrillo no tiene antecedentes.
That being said, I'm requesting a $7,500 bond and no victim contact.
Aún así, voy a solicitar una fianza de $7,500 y que se le prohíba tener contacto con la supuesta víctima.
This is based on the level of violence, alleging that Mr. Carrillo punched the victim in the face,
Dado el nivel de violencia que supuestamente se desplegó, en donde se dice que el señor Carrillo le pegó una puñetada a la víctima en la cara,
bit her in the back,
la mordió en la espalda
and then ultimately strangled her.
y al final la estranguló.
Mr. Romero.
Gracias. Señor Romero.
Judge, as you heard, Mr. Carrillo has no prior contact with the criminal justice system.
Señora juez, como ya escuchó, el señor Carrillo no ha tenido contacto de previo con el sistema judicial penal.
He's been living in our community for the past 5 years. He's 22 years old.
Tiene 5 años de vivir en nuestra comunidad, tiene 22 años.
He works in construction. He's been working with the same construction company now for about 2 years.
Trabaja en construcción, ha estado trabajando con la misma constructora por aproximadamente 2 años.
He lives locally here in Fort Lauderdale, where he's been renting the same apartment for the past year.
Vive acá en Fort Lauderdale, donde ha estado alquilando el mismo apartamento durante el último año.
He's going to be reaching out to his father to help post his monetary bond, and my understanding is he works also in construction.
Le va a pedir a su padre que le cubra la fianza monetaria y tengo entendido que el padre también trabaja en construcción.
Judge, his father and Mr. Carrillo's financial resources are limited. They're not going to be able to afford what the state has suggested as far as $7,500 bond.
Señora juez, los recursos económicos del señor Carrillo y de su padre son limitados. No van a poder costear el monto establecido de $7,500.
I understand the nature of the allegations are serious. However, perfectly candid, I haven't had an opportunity to review the PC affidavit.
Entiendo que las acusaciones son serias. Para ser perfectamente honesto, no he tenido oportunidad todavía de evaluar el affidavit sobre indicios probables.
But my understanding, it was both Mr. Carrillo and the alleged victim that both contacted law enforcement.
Pero según tengo entendido, fue tanto el señor Carrillo como la supuesta víctima. Ambos contactaron a la policía.
I did advise Mr. Carrillo he will have his day in court to contest these allegations, but my understanding is he was defending himself when the victim was the first person that actually produced the knife.
Y le he informado al señor Carrillo que él tendrá la oportunidad de defenderse ante el juez respectivo. Sin embargo, según se me informa, el señor Carrillo se estaba defendiendo. Fue la víctima quien produjo el cuchillo en primer lugar.
So therefore, besides our monetary request of $3,000, we're also going to be asking the court to sign a photo order so we can photograph the injury that Mr. Carrillo sustained as a result of the incident with the alleged victim.
De manera que, además de lo que ya hemos externado, vamos a solicitar que su señoría autorice una orden fotográfica para que se le tome una foto a la lesión que sufrió el señor Carrillo.
Does Mr. Carrillo reside with the alleged victim?
¿Vive el señor Carrillo con la supuesta víctima?
He does, but my understanding is the wife left the premises.
Sí, reside ahí, pero tengo entendido que la esposa abandonó ya el sitio.
Honor, and we really don't know. I mean, for all we know, she left for a night for concerns for safety. You know,
Su señoría, en realidad no sabemos. O sea, hasta donde sabemos puede ser simplemente que se fue por una noche porque estaba preocupada por su seguridad.
And I understand. I spoke to Mr. Carrillo. I told him one of the conditions of his release is going to be no contact. So if the victim is living there, the court has jurisdiction over him. He has to abide by the court order as far as no contact. But obviously, if she's not there, then he can return to his premises.
Y yo entiendo, su señoría. Le he informado al señor Carrillo que él va a tener prohibido el contacto con la supuesta víctima y él está dispuesto a obedecer eso. Si la víctima está ahí, pues no puede tener contacto con ella. Pero si no lo está, entonces no estaría en violación de la orden de no mantener contacto al regresar ahí.
Correct, but that's also with the understanding that if she does return, he will have to leave.
Así es, pero eso es en el entendido también de que si ella regresa ahí, él se tiene que ir.
All right,
Understood.
the probable cause affidavit makes no mention of any aggression on the part of the victim or any reference to a knife.
El affidavit sobre indicios probables no hace referencia alguna a algún acto de agresión por parte de la víctima, ni tampoco a un cuchillo.
Based on the level of violence that has been indicated in the probable cause affidavit,
Dado el nivel de violencia desplegado según el affidavit sobre indicios probables,
I'm going to impose a $5,000 bond
voy a imponer una fianza de $5,000
with a no victim contact order.
y se le ordena no tener contacto con la supuesta víctima.
Mr. Carrillo, a no victim contact
Señor
means
Carrillo, el no tener contacto con la víctima significa
no phone calls,
no puede hacer llamadas telefónicas,
no text messages,
no puede enviar mensajes de texto,
no third party contact,
no puede contactarla mediante
no
terceros,
social media.
ni tampoco por redes sociales.
Do you understand that?
¿Entiende? I understand.
All right, and I will sign the photo order
Bien,
that
y
was
sí voy a
requested.
firmar la orden autorizando que se le tome una fotografía.
Thank you, Judge.
Thank you.
Gracias, señora juez.
Edwin Jacome Fajardo.
Edwin Chacón Fajardo.
Judge, he's here present. I asked him. He declined the services of public defender.
Sí.
He's going to hire his own private attorney.
Señora juez, él está aquí presente. Él ha rehusado los servicios de la defensa pública, va a contratar a su propio abogado.
All right. Mr. Jacome Fajardo,
Bien, señor Chacón Fajardo,
do you understand that you are entitled to have an attorney represent you for this hearing?
¿entiende que usted tiene derecho a que lo represente un abogado en esta audiencia?
Sí.
Yes.
And you are refusing the services of the public defender at this time?
¿Y está rehusando los servicios de la defensa pública en este momento?
No.
No.
Okay.
Judge, can we put this on brief recall then?
Señora juez, ¿podemos hacer una breve pausa entonces?
let me just find out if anyone else needs an interpreter, because otherwise
Permítame
I
averiguar si alguien
don't
más
want him to
necesita
have to wait.
intérprete.
All right, is there anyone else at Maine that needs an interpreter?
¿Alguien más ahí en la cárcel principal necesita intérprete?
Okay, is there anyone at any of the other facilities that needs an interpreter?
Yes, Your Honor. On page 4 of the court's docket at Paul Rhine, there is Claudia Valdez Carbolo.
Where is Ms. Valdez Caraballo? I'm sorry, what's the issue? Oh, excuse me, I did say 5. I apologize. I wrote 5 in my notes. Thank you. All right, thank you. We can't be doing this on the He needs, we're not, I don't want you to take that. I wanted to stay here, that's fine. Like, I don't know what's going on. Just leave that there. All right, let's try this again. Ms. Valdez Carvalho,
Señora Valdés Carballo,
you are before the court. I believe that these are ad charges.
está ante este tribunal, creo que hay cargos adicionados.
You have an immigration hold,
Tiene una orden de captura por inmigración
and you are being held no bond on
y
that count,
no hay fianza posible para ese cargo,
which means that you will have to go before an immigration judge.
lo cual significa que tiene que comparecer ante un juez de migración.
So at this time, you will continue to be held no bond.
Así que en este momento usted seguirá detenida sin fianza.
I do find probable cause.
Considero que existen indicios probables.
All right.
¿Podría hacer una pregunta?
Can I ask a question?
Yes.
Sí.
Es que no he podido comunicar con mi familiar porque simplemente no me sé el número de teléfono y están mis contactos del celular.
I
A
haven't
ver
been
si
able
podría...
I haven't been able to communicate with my relatives because I just don't know the number. The number is in my cell phone.
I'll be happy to sign a phone order.
No hay ningún problema con firmar una orden autorizando que tenga acceso a su teléfono.
Well, I'll sign it once you give it to me.
Gracias.
Thank you.
All right. Thank you. Good luck.
Gracias, buena suerte.
Okay. Is there anyone else at any of the other facilities that needs an interpreter?
Not info right now.
Okay. Anyone at Concierge North Broward?
Not that I've been advised, Judge.
Okay. So as soon as,
Judge, we're ready to proceed on Mr. Jacome Fajardo.
okay. All right. So Mr. Romero, are you going to be representing him for the
Señor
hearing?
Romero, ¿lo va a representar? Sí.
I am, Judge.
Okay. All right. Mr. Jacome Fajardo,
Señor Chacón Fajardo,
you are before the court on count 1,
usted está ante esta corte acusado primeramente
touch or strike battery domestic violence,
de lesiones por toque o golpe en violencia doméstica.
and count 2 is an immigration hold,
El segundo cargo es una orden de captura de migración
which has a no bond hold on it.
y para ese cargo no hay fianza posible.
I do find probable cause,
Considero que existen indicios probables
and I will hear from the parties should they wish to make an argument.
y escucharé a las partes si desean externar un argumento
That's to count 1.
con respecto al primer cargo.
Judge, my understanding, Mr. Jacome, this is his first time being arrested in his life.
Señora, pues tengo entendido que esta es la primera vez en su vida que el señor Chacón ha sido arrestado.
My understanding, Judge, he is working. He works for a roofing company.
Tengo entendido, señora juez, que él trabaja para una compañía de techos.
He's been living in our community for the past 14 years.
Ha estado viviendo en nuestra comunidad durante 14 años.
He did advise me that he understands as far as the no contact order, he will be abiding by that no contact order.
Me informa que con respecto a la orden de no mantener contacto, él la va a respetar.
Now, he does advise me that he has family that reside in our community,
Sí me indica que él tiene familiares que viven en nuestra comunidad,
that he's going to be reaching out to and hoping that they could help post his monetary bond.
a quienes va a contactar con la esperanza de que ellos puedan cubrir su fianza monetaria.
Judge, considering this is a misdemeanor offense, and if the state can confirm he has no prior contact, I'm
Tomando en
requesting a $1,000 bond.
Tomando en cuenta que esto es una contravención y si podemos verificar que no ha tenido previo contacto con el sistema penal, solicitaría una fianza de $1,000.
That's fine,
And
Your
a
Honor. I
phone
was going to
order
be
as well.
requesting a $1,000 bond.
Está bien, su señoría. Yo de la fiscalía iba a solicitar también una fianza de $1,000.
All right, the bond on count one will be $1,000.
Bien, la fianza para el primer cargo queda en $1,000.
And there will be a no victim contact order.
Y habrá una orden de no mantener contacto con la víctima.
That means no phone calls,
Eso significa que no la puede llamar por teléfono,
no text messages,
no le puede enviar mensajes de texto,
no third party contact,
no la puede contactar mediante terceros,
no social media.
ni por redes sociales.
Do you understand that, sir?
¿Entiende eso, señor? Yes.
All right, and that will be until further order of the court.
Y eso será hasta que se disponga lo contrario acá.
Thank you.
Gracias.
Okay. Have we heard anything back from Mr. Glassman on Mr. Glassman?
I'll check again with them, Your
All
Honor.
right, in the meantime, I'll go to Mr. Shade's case.
Is that all for the Spanish cases, Your Honor?
I just want to confirm one more time, Mr. Romero, there's no one else at Maine that needs an interpreter, correct?
Espanol, nobody else here, Judge.
Okay, thank you so
Thank you.
much. All right. Mr. Shade, good morning.
Morning, Judge. I think some of them maybe medical resets can still.
Okay, so let's see, I'm gonna just go down my list here. I have,
First one would be Amber Wright.
yeah, let me just see here. I have
Is she that?
Amber Wright is up first. Where is she?
North Broward.
Okay. Thank you.
The offer from the city judge would be time served.
It's an adjudication time served. All right, good morning, Ms. Wright.
Good morning.
You're before the court on count one, which is possession or use of drug paraphernalia, and count two is a municipal ordinance violation for solicitation.
Now I have a question because I went to court yesterday. What was that for?
Judge, she was in Judge Lerner Rent for some matter. I'm not quite sure exactly what it was.
I went to court yesterday. I thought for these charges already.
Okay, let me just confirm because count one is the misdemeanor case. Was count one what she was for? She was, I'm sorry. I see. Okay. Well, I need to know if she wants to resolve count two, we can do that, but I'm gonna have to check on count one as to what's going on with the other case.
From what Miss Wright told me, Judge, yesterday in front of Judge Lorna Wren, she apparently was ordered to go to a hospital.
Okay.
So, but there's no mention of that in Odyssey. It just says that there was a hearing yesterday. It also indicates that she has a hearing on January 14th as well. I don't know if confinement status has any more information on that.
Please do
How
because
much-
Hold on, Miss
Hold
Wright.
on.
sorry.
Yes.
And the fact that Judge Lerner Rand already scheduled her next administrative status hearing would indicate that there was action taken and she wants to see her back in there.
And then, what I'm gonna do is, I'm not going to take a plea at this time.
fine, Judge.
We can have the MO case sent to Judge Lerner Wren as well, so that the two cases can be handled at the same time, hopefully.
So how long is how long will I be in jail until this hearing?
They're already both there.
Okay, they're already in front of her.
Yeah, I
So you
checked.
have, Ms. Wright, what they're telling me is that you have a hearing before Judge Lerner Wren already scheduled for the 14th, which she had set yesterday when you were in front of her, okay?
That's what I'm saying. What might have happened was the times I was supposed to go to court, I end up detoxing or whatever, like trying to sleep, okay?
Okay.
That might be what that's from. You know what I'm saying? Is
All
that
right.
true?
Well, Ms. Wright, you'll have to talk to Judge Lerner Wren, who's your division judge, about it, okay? I can't address that issue right here in first appearances. So for now.
So how far is the 14th away?
6 more days.
So I had to be in jail for 6 more days.
Yes, Ms. Wright, that's what Judge Lerner Wren has requested, okay? So you'll talk to her about that when you go back in front of her, and
The
you can
black
discuss
hair
it.
lady hold on, the black hair lady with the glasses.
Yes, that's Judge Lerner Red.
Why didn't she? Now this is my question. Why didn't she tell me that yesterday?
Miss Wright, I can't answer that because I wasn't there, but you can discuss it further with your attorneys after the hearing today, okay?
Because hold on, the bond is $100 for my charge. So why
Yes.
am I going through so much just for $100 bond?
Okay, well, Miss Wright, you're gonna have to, Miss Wright, you're gonna have to talk to your attorneys about that after the hearing today, okay? Good luck to you.
I have one more question. Hold on. Is there a way where I can go to a hospital, be there for a couple of days, and then go to court from there? Because she said that she was supposed to send me to a hospital.
Miss Wright, you're gonna have to talk to your attorneys about that after the hearing today, okay?
I don't have an attorney.
I think that's what's happening.
Yes. Okay. All right. Okay, next up I have Erica Lovesmith. I believe she was a medical reset.
She was a medical reset yesterday.
Is she in today?
She'll be North Broward.
She's a medical reset today, Judge.
Perfect.
Love Smith? Yeah.
Okay. Next up is Robin Simmons.
He's in
Do we know where Robin Simmons is? Okay.
Paul Ryan. Okay.
All right.
Time served, Dr. Judge.
Okay. Good morning, Miss Simmons.
Good morning, Your Honor.
All right, you're before the court on a municipal ordinance violation for solicitation. I do find probable cause, and Mr. Shate, you said it's a time
Time
served?
served, Dr. Kirk.
All right, Ms. Simmons, do you want to resolve your case today? The offer of
Yeah.
adjudication, time served.
Time served.
Do you want to resolve it?
Yes.
Okay, will you raise your right hand for me? Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. Do you understand everything that's been discussed here today?
Yes.
Okay, is anyone forcing you to resolve your case?
No.
Are you under the influence of any drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to a trial, but you're waiving that right by accepting a plea here today?
Yes.
Have you ever been treated for mental or emotional illness?
No.
Do you understand that if you are not a U.S. citizen, that by taking a plea today, you will be subjected to deportation or other immigration changes?
Yes, Your Honor.
Okay. What plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea and find that it is freely and voluntarily given, and the sentence will be an adjudication, time served.
Thank you, Your Honor.
Thank you, Ms. Simmons. Good luck. Okay, and last I have Matthew Gaines. Where's Mr. Gaines?
Same page. He's probably a medical reset as well. Page 11. Easy to know.
Okay. Well, I don't see Mr. Glassman here, so I'm just gonna start going down our list. Okay, Maureen Gale.
No problem.
Mr. Shade, are you representing Ms. Gale? This is a capias for an MO case. Good morning, Ms. Gale.
Good morning.
Oh, I am, Judge. I'm sorry.
Okay, that's all right. Okay, so Ms. Gale, you're before the court on a capias in a municipal ordinance violation case for panhandling. I do find probable cause, and Mr. Shate is here.
Judge, it's just a panhandling matter. The city would offer time served on these.
Okay, Ms. Gale, do you want to resolve the case today?
Yes, ma'am.
Okay, the offer is going to be an adjudication, time served. Do you understand that?
Yes.
Okay, will you raise your right hand for me? Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. Ms. Gale, do you understand everything that we've discussed so far today?
Yes, I do.
Is anyone forcing you to resolve your case?
No,
Are you under the influence of drugs or alcohol?
I'm being detoxed.
Still being no. But you haven't consumed any alcohol or drugs in the last 24 hours, have you?
No,
Okay. All right. Miss Gale, do you need any more time to speak with your attorney?
no,
Okay. Do you understand that you have the right to a trial, but you're waiving that right by accepting a plea here today?
yes,
Have you ever been treated for mental or emotional illness?
yes,
Is there anything about that illness today that impacts your ability to accept this plea?
no, Your Honor.
Okay. Ms. Gale, do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
Yes, I understand that.
Okay. And what plea do you wish to enter? Guilty or no contest?
No contest.
All right. Thank you. I accept your plea and find that it is freely and voluntarily given. The sentence is going to be an adjudication, time served. Thank you, Ms. Gale.
Thank you, Your Honor.
Okay. Jade Ashley. Do we know Miss Ashley? Okay. I find probable cause. Brenda Cooper.
North Broward Medical Reset, Your Honor.
All right. Thank you. Lawana Martin. Okay. Thank you. All right. We have no one at Paul Ryan again.
Yes, Judge, I spoke with Miss Martin. She indicated to me that her friend is going to be able to bond her out.
Okay. Oh, she's already bonded.
Oh, she's bonded. Okay.
Okay. All right. I find probable cause. Thank you. Rose Howell.
Hi, North Broward. Morning.
Okay. Good morning, Miss Howell. All right.
Morning.
Miss Howell, you're before the court on one count of possession of cocaine. I do find probable cause, and I will hear from the parties.
Judge, Miss Howell indicated to me that her husband is going to be posting her bond.
Okay. All right. In light of that, I will leave the standard bond in place then. Okay.
I'll give him a call right after court, Miss Howell, to make sure, okay?
Thank you.
Thank you. Charles Spicy Bell. All right. Good morning, Mr. Bell.
Morning.
All right, Mr. Bell, you're before the court on one count of aggravated battery causing bodily harm, dating violence. I do find probable cause, and I will hear from the parties. Okay.
Your Honor, I'm going to be requesting a $15,000 bond, pretrial release GPS, monitor level 2, no victim contact. This is based on the level of violence, the allegation that Mr. Spicy Bell struck the victim and fractured her orbital bone. Additionally, in 2017, he was convicted of strong-arm robbery, sentenced to 22 months state prison, released September 6th of last year. 2017, Grand Theft Auto, sentenced to 2 years state prison, August 30th of this year. 2017, he was convicted shooting at or throwing a deadly missile and domestic violence battery. That was against a different alleged victim. He violated his probation in that case. Nothing further, Judge.
Judge, I understand the nature of the allegations are serious. I understand that Mr. Green has a prior record, but unfortunately he's not going to be able to. Mr. Spicy Bell has a prior record, but unfortunately he's not going to be able to come up with that monetary amount. Now, we don't object as far as having Mr. Bell supervised by pretrial release. But besides, we're going to also be asking for a bond reduction from what the state has indicated. We're going to be asking for about $3,500. Now, in speaking to Mr. Bell, he's been residing here his whole life. He's 22 years old. He just got his job. He's working at Burger King. He got his first paycheck. It was $69. He gets paid only $8.50 an hour. He's going to be reaching out to his mother to help post his monetary bond. She works at a daycare, so her funds are limited. He really much wants to be on the outside in order to fight these allegations. Also, he wants to be there for his grandmother. His grandmother's going through some health crisis. I believe she's currently in the hospital or seeking some sort of medical help. But Judge, I'm asking for a $3,500 bond with pretrial release and a photo order as well.
Just in time.
Are you here on this case?
Yes, ma'am.
Our bondsman here. Do you want to tell me anything?
Yes, I did speak to his mother, who's Miss Lakeisha, and his grandmother is in ICU. She's on fixed income disability, so she doesn't have much money.
Well, I sympathize with the fact that he wants to be with his grandmother who's in ICU. I'm a little concerned by some of the allegations in the probable cause affidavit. Based on what I'm seeing here, he allegedly struck the victim with a closed hand fist. Apparently at some point she ended up unconscious, doesn't remember how she ended up from a bedroom to laying on a front porch of the residence, and then later ended up in the hospital with a fractured orbital bone. Based on his priors and what I'm seeing here, I am going to impose a $7,500 bond. If Mr. Spicy Bell does bond out, he will be on pretrial release with the GPS monitor level 2. There will be a no victim contact order in this case. Mr. Spicy Bell, no victim contact means no phone calls, no text messages, no third-party contact, no social media with the alleged victim until further order of the court. Do you understand that?
Yes, ma'am.
All right, thank you.
Court ordering him to remain at least 500 feet away from the alleged victim at all times.
Yes, there's going to be a 500-foot stay away order as well. Thank you.
And Judge, before we go on to the next case, I spoke with Mr. Glassman. Seems to have been some confusion. It turns out he has not been retained. He's not going to be appearing at this time, so we can proceed with Mr. McLean's case whenever the court wishes.
Speak with him.
Sure.
Additionally, in Mr. Spicy Bell's case, the defense requested a photo order, which I will sign.
Thank you, Judge.
You're welcome. All right. Mr. Romero, are you ready to proceed with Mr. McLean's case?
Yes, Judge.
Okay, all right, Mr. McLean, you're before the court on count 1, murder, dangerous or depraved without premeditation. Count 2, committing a first-degree felony with a weapon. Count 3, driving while license suspended, first offense. I do find probable cause for these charges, and I will hear from the parties.
Thank you, Your Honor. The state would be seeking a finding of proof evident or presumption grade on count 1. For first appearance purposes only, request that Mr. McLean be held no bond. I'm not seeking to have any bond attached on count 2. It's really subsumed by count 1. Just noting the evidence in the affidavit, Your Honor. Based on the statements from the witness, Your Honor, the video surveillance evidence, that there's video surveillance of that corroborated the victim's version of events. Mr. McLean was seen wearing clothing matching the description given by the victim or the witness. He was identified by his father from video surveillance evidence. His father provided testimony placing him in physical possession of the vehicle that was captured on video surveillance as part of this incident. and based on admissions made by Mr. McLean and a passenger in his vehicle, that he was present in the vehicle at the time of the incident, that he was in possession of a firearm and did fire multiple shots, at least one of which ultimately killed the victim in this case.
Object to the court making a finding of proof, evident, presumption great at this time, since that's the highest standard of proof that we have in the criminal justice system. The state's introduced no evidence. They did talk about a lot of evidence, but they haven't introduced any. I understand this is a road rage type of incident, at least according to what the probable cause affidavit would indicate. So we would ask you to set bond for Mr. McLean. If the court's not inclined to do that, or is inclined to make a finding of proof, evident, presumption great, would ask the court to exercise its discretion. Mr. McLean is 21 years old. Also, I'm going to advise Mr. McLean and the state as well that we are invoking his Fifth Amendment right to remain silent. We're asking that the state, nor any of its law enforcement agencies, contact Mr. McLean without first contacting his attorney. And Mr. McLean, I'm advising you, sir, do not talk to anyone but your attorney about this case. That includes any conversations on the phone. They are recording your conversations, and they will be used against you at trial. Do you understand, sir?
Yeah.
Okay.
All right, this was a road rage incident based on the allegations that are included in the probable cause affidavit, many of which are supported by multiple witness statements as well as video surveillance, as well as Mr. McLean's statements himself. This may have been a road rage incident, but this happened some time ago, and Mr. McLean did not come forward per his own statements included in the probable cause affidavit. I'm also disturbed by the fact that this incident, according to what I'm seeing in the probable cause affidavit, appears to have taken place in the presence of other passengers, including 2 infant children. Based on the allegations that have been included in the probable cause affidavit and the charges that have been brought, I am going to make a preliminary finding of proof evident presumption great as to count 1. This is without prejudice for Mr. McLean to have a hearing before his division judge, but for the time being, he will be held no bond.
I have no objection to an ROR in count 2.
Standard bond will remain in place for count 3. Thank you. All right, next up is Antonio Green.
He's approaching, Judge.
Thank you. All right, good morning, Mr. Green. You're before the court on 1 count of aggravated battery, where the offender knew or should have known the victim was pregnant, domestic violence. I do find probable cause. I will hear from the parties. Looks like we have your, let me just see if Bonson's present on this case. Okay.
That's pretty common, actually. Your Honor, based on the level of violence and the fact that Mr. Green is currently out on bond for aggravated assault with the firearm and carrying concealed firearm, requesting a $10,000 bond, no victim contact.
Judge, I understand Mr. Spicebell is out on a case right now, as the state said, but from what he advised me, he's been going to court. He has a court date actually scheduled for tomorrow. My understanding is, I believe he's gone to court about 3 times, so he is going to court. Having said that, Judge, he advised me he's not in a financial position to post any sort of a bond. He is requesting that the court consider releasing him on pretrial release. My understanding is he's been working for the same company, Tri-County Cleaning Service, for the past year. He gets paid bi-weekly. My understanding, Judge, he will be living separate and apart from the alleged victim. He'll be residing with his mother, who lives locally in Fort Lauderdale, but unfortunately, she's not in a financial position to post his bond. She is on disability. So having said that, Judge, Mr. Bell is requesting to be released on pretrial release.
Well, Mr. Romero, I appreciate your argument, but that's not going to happen today. Based on the charges that he's already out on and the allegations that are included in the probable cause affidavit, including the allegations that he apparently punched the alleged victim in this case, who is 4 months pregnant with his child, in a public restaurant in front of other witnesses whose statements have been provided to law enforcement officers. I'm not going to release him to pretrial. I will impose a $10,000 bond with a no victim contact order. Mr. Green, no victim contact means no phone calls, no text messages, no third-party contact, no social media until further order of the court. Do you understand that?
Yes.
Thank you. August Ingelis.
Mr. Ingelis?
Can you grab this one? All right, good morning, Mr. Ingelis. You're before the court on one count of battery on a person 65 years of age or older. I do find probable cause. I will hear from the parties. It appears
Your
your
Honor.
bondsman is present. Well, I'll hear state if you would like to go first. Go ahead.
Thank you, Your Honor. I see no history, just based on the totality of the circumstances. I'd be requesting a $2,500 bond and no victim contact.
Judge, I see James is there present. I wanted to know if he's here for this case.
Yes, I spoke to his brother, Joseph.
Okay. Anything that you want me
Will
to?
his brother be able to afford to post that monetary bond?
Yes, he'll be able to post it.
Okay. All right. Based on what I'm seeing here, then the bond will be set at $2,500. There will be a no victim contact order. Mr. Angelis, there's going to be a no victim contact order. According to what I'm seeing in the probable cause affidavit, you do live across the hall from the alleged victim in this case, is my understanding. You can speak to your attorney about this further, but I need you to understand there is a no victim contact order. That means no phone calls, no text messages, no third-party contact, no social media, no being in the same place at the same time. Do you understand that?
Yes, I do, Judge.
Okay. All right. Thank you.
Judge Deal?
Thank you,
Clarification, I just wanted to know the court's not imposing the 500-foot restriction, correct?
No, based on what I'm seeing, I'm not going to impose that.
Thank you, Judge.
You're welcome. Richard Ekmiro. Morning, Mr. Ekmiro. You're before the court on count 1, driving while license suspended. Second offense. Count 2 is a probation violation, which has a no bond hold on it. I do find probable cause. I see that you have a hearing before your divisional judge on the 9th. Do the parties wish to make any argument on count 1?
Nothing from the state, Judge.
Not at this time, Judge.
Okay. In light of that, I will leave the standard bond in place on count 1, and you will see your divisional judge on the 9th. Thank you. Kent Comu.
So I think it's Como, Judge. He's in North Broward.
Okay, thank you. All right, Mr. Como, how are you?
Good morning, Your Honor.
All right, Mr. Como, you're before the court on count 1, DUI, alcohol or drugs, first offense. Count 2 is a DUI with the blood alcohol content greater than 0.15. Count 3 is a DUI with damage to property or person of another. I do find probable cause, and I will hear from the parties.
Judge, I'm going to ask the court to consider pretrial release for Mr. Como. He's been living here in South Florida for the last 10 years. He has some college background. He went to LSU. I believe his last contact with the criminal justice system was about 3 years ago. And he's asked me to try and reach out to his ex-wife to post a bond Unfortunately, he's not sure of her number, and the numbers that he's been calling from the jail have not been successful. I'm not all that confident right now that we're going to be able to get a hold of his ex-wife to post a monetary bond.
Okay, state.
Your Honor, I'd have no objection to pretrial with random testing, no alcohol or intoxicants.
Does he have any priors?
That would be fine.
There's a dated previous arrest out of the state of Colorado for a DUI. I don't have a disposition.
All right, in light of that, I have no issue with RRing Mr. Como on all 3 counts to pretrial, but Mr. Como, you will be subjected to random testing, no alcohol, no intoxicants during this time. Do you understand that?
Yes, Your Honor.
All right, so Mr. Como, you're going to get the information for pretrial before you leave there. You need to report to pretrial services within 24 hours. If you do not do that, then a warrant will be issued for your arrest. Do you understand that?
Yes, Your Honor.
Okay, thank you.
Good luck, Kent.
James Wilson?
Also North Broward, Your Honor, and Mr. Wilson would like to resolve this matter this morning if possible.
All right, Mr. Wilson, you're before the court on a misdemeanor capias. I do find probable cause. State, do you have an offer in this case?
Your Honor, I can advise the court. He was referred to Judge Litteren's mental health division by the mental health specialist at the jail. I see at least 2 prior cases in the past when he's gone through mental health divisions, both on a misdemeanor offense and a felony.
Were those recent cases?
I'm sorry?
Were those recent cases?
2014, 2015.
I would say I didn't have any real problem communicating with Mr. Wilson. He was able to provide me with background information and advise me of his medical condition that he currently has. Also advised he'd be living with his mom. Unfortunately, he's unemployed at this time. He can't make a $500 bond. He does want to resolve it. So, I mean, you know, I know that these evaluations are done. I don't know exactly how thorough they are or who even does them, but I know that they do not necessarily address the issue of competency. It's more of an idea that, well, this person does have some issues, so maybe they should go to Judge Lerner-Wren, but it doesn't state that they're not competent to enter a plea either.
All right. Well, State, do you have an offer if he does want to resolve it?
Just so the court's aware, because you asked for the recency of the cases, on the felony case, he was on mental health probation until May of 2018. As far as an offer, the offer would be adjudication time served.
Do you understand that, Mr. Wilson?
Yes, sir.
Is that what you would like to do this afternoon or this morning?
Yeah.
Okay.
Yes, sir.
All right. All right. So, Mr. Wilson, you want to resolve your case today?
Yes, ma'am.
Okay. Will you raise your right hand for me? Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay. You can put your hand down. Mr. Wilson, do you understand everything that's been discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am. No.
Are you under the influence of any drugs or alcohol?
Not right now, no.
Okay. Do you need any more time to speak with your attorney?
No, ma'am. No.
Do you understand that you have the right to a trial, but you're waiving that right by accepting a plea here today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
Yes, ma'am.
Is there anything about that illness today that impacts your ability to accept this plea?
No, ma'am.
Okay. Do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
All right. What plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea, and I find that it is freely and voluntarily given. Your sentence will be an adjudication, time served.
Thank you, ma'am.
Good luck to you, Mr. Wilson.
Okay.
Raul Silverio. Do we know Mr. Silverio? All right, good morning, Mr. Silverio. You're before the court on count 1, driving while license suspended, second offense, and count 2 is an out-of-county civil hold. That's out of Orange County. I do find probable cause, and I will hear from the parties.
And to speak, Mr. Silverio, he wishes to resolve count 1. We want to see if the state had a plea offer for him.
Do you have a driving record, Your Honor? I don't even take
No, I
a
don't
minute
have
to
one
pull
in
his
front of
driving
me.
record.
This indicates it's his second offense, but that's all that I have.
Yeah, that doesn't,
That's the only
I
thing.
don't always pay that much attention to the second offense, first offense part.
Yeah.
I see multiple. Yeah, it looks, this actually wouldn't be a second. I believe pleading to this case at this time would require a mandatory 10 days in county jail based on new law.
Out of that, I'm not going to, even if there were an offer, I'm not going to take a plea today, but I will hear from the parties as to bond. The bond on count 1 right now is $100.
Your Honor, I just request that the bond be kept in place. I'm just looking at his driving record. I'm showing multiple suspensions for failures to appear.
Judge, the only thing I can request, he's been in contact with his mother. He can post a $100 bond on count 1, but then what that's going to trigger is the problem on count 2, because he would be using the funds in order to pay the purge amount. So therefore, Judge, our only request at this time, if the court's willing to ROR count 1, so that whatever funds he has can use towards the purge amount on the child support for count 2.
Your Honor, respectfully, looking at his driving record, he's had these suspensions for failing to pay child support since 2015. To now say, well, I shouldn't have to pay bond because now I'm ready to start paying my child support.
See that on the driving record, there are multiple suspensions for, including the failures to appear and the child support issues. So at this time, I'm going to leave the $100 bond in place. All right, thank you. Michael Henderson.
Henderson, come on up, please.
All right, good morning, Mr. Henderson.
Morning.
You're before the court on a traffic capias. I do find probable cause.
Judge, Mr. Henderson wants to try and resolve this case today.
And Your Honor, the state's offered to be a withhold. This in court cost, even though he'd be resolving it now, obviously this occurred prior to the change in the law, so the state would not be seeking and have no objection to the court not imposing the 10-day mandatory sentence.
But he wishes to accept the state's offer.
All right.
The only thing, Your Honor, that he needs, well, actually, no, he'd be fine. He just needs to know his other DWLSs, the last one was resolved in 2011, so this would be a first one within a new 5-year period.
All right. Mr. Henderson, will you raise your right hand? Do you swear or affirm to tell the truth?
Yes.
You can put your hand down. Do you understand everything that's been discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to a trial, but you're waiving that right by accepting a plea here today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No.
Do you understand that if you are not a U.S. citizen, that accepting a plea today will subject you to deportation or other immigration changes?
Yes.
Okay, what plea do you wish to enter? Guilty or no contest?
No contest.
All right, I accept your plea and find that it is freely and voluntarily given. Mr. Henderson, once again, the sentence in this case will be a withhold of adjudication and court costs. Michael Santana,
He's approaching, Judge.
thank you. Good morning, Mr. Santana. You're before the court on one count of trespassing, occupied structure, or conveyance. I do find probable cause, and I'll hear from the parties.
Judge, Mr. Santana is wanting to resolve this. We want to know if the state had a plea offer for him.
I do, Your Honor. It would be an adjudication, time served, no return. But Mr. Santana should be aware, he was just arrested on the 23rd for trespassing at the same location. He pled the case out. He was court ordered not to return to this coin laundry. If he comes back, certainly, if he comes back in the near future, the state's offer will involve jail time.
He understands, Judge. He wishes to accept the state's offer.
All right. Mr. Santana, will you raise your right hand for me? Do you swear or affirm to tell the truth?
Of course.
All right, you can put your hand down. Mr. Santana, do you understand everything that's been discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
Is anyone forcing you to resolve your case today?
I plead no contest. Oh, no,
No one's forcing you?
I don't think so.
Judge. One moment, please.
Has he ever been referred to the mental health division?
I'll check.
Judge, at this time, I don't think Mr. Santana fully understands what's going on. I don't feel comfortable in resolving this offense. Mr. Santana did advise me that he's homeless. He has no way of monetary bond. I did understand whatever happened today, the court, even if it didn't resolve, would order no return to this premises. He told me he would abide by that. So, Judge, I'm asking at this time if the court would consider releasing Mr. Santana.
First off, Your Honor, I do see on one case in 2016, he went through Judge Leonard Wren's division. I'm not confident if he's unable to understand the questions to take a plea, that he is going to fully understand the instructions not to return and to come back to court. I'd have no objection if the court was inclined to transfer Mr. Santana's case to Judge Leonard Wren.
I think that that's probably the best for now. Judge Lerner Wren is obviously in a better position to see if there are any additional services or help that can be provided to Mr. Santana. So at this time, I'm going to leave the bond in place, and there will be a no return order on the file. So we'll see if Judge Lerner Wren can get him in front of her relatively quickly.
I'll advise her judicial assistant.
All right, thank you very much. Carl Noel,
Mr. Noel? Carl
he
Noel?
was removed from the docket.
Oh.
Okay. Okay, I'm just gonna hand this on over. All right, Bernard Gonzalez.
He's approaching, Judge.
Thank
Come on up, sir.
All right, good morning, Mr. Gonzalez. You're before the court on an ad charge. This is a charge for selling heroin. I do find probable cause. I'll hear from the parties. I understand there are some special bond conditions that are in place in this case.
Yes, Your Honor. Have 1 moment.
Judge, we just wanted to know on count 17, the ad charge, when's the alleged date of incident?
I believe in state, you can confirm this, I believe this is for April 8th, 2019,
Yes, ma'am, that is correct.
for the affidavit that was submitted.
Your Honor,
Yes.
Mr. Gonzalez is currently being held no bond on murder in the first degree. My understanding is that the allegations involves dealing of fentanyl or PVP and an overdose. Based on that and the allegations in this case, I'm requesting that Your Honor keep the bond that Judge Usan set in place and all the special release conditions.
Okay.
And Judge, considering he has a no bond hold, I spoke to Mr. Gonzalez. I believe on other cases he has private counsel, on some of them he has PD. I believe on this he's applying for a public defender. So considering he has a no bond hold, Judge, nothing to add at this time.
All right, then I'm going to leave the $30,000 bond in place as set by Judge Usan, and all of these special bond conditions set by Judge Usan will remain. You can just write special, okay. Anthony Seeley?
I'm advised he's downtown, Judge.
Okay. Then we'll reset him. Michael Catania?
Your Honor,
Yes.
before we, the only issue, do we know is Sealy, if I could check one thing. If you notice for Mr. Sealy, it's saying that he's set for hearing tomorrow.
Yes, I do see that.
I just want to make sure that he's not down there on that case right now, because then we can sometimes get into a loop. where-
Okay, so then let's confirm that
I'm
before
gonna
we
check
move
right
on.
now in Odyssey. He's actually scheduled for a violation of probation hearing before Judge Lynch this morning on these cases. The only request I'd make is if you could ask the clerk to cancel the 1-9 hearings that are set, so to make sure he comes before Your Honor on the new theft.
Yeah, he's gonna be canceled, the 1-9 hearing is canceled, because he's before Judge Lynch right now on the VOP. And he'll come before us here on the petty theft charge. That needs to be reset. Thank you. Okay, So we're ready to move on? Next up will be Michael Catania.
Yes, ma'am.
Where's Mr. Catania? All right, good morning, Mr. Catania.
Morning.
You're before the court on 3 ad charges for burglary, unoccupied dwelling unarmed, petty theft, first degree, and criminal mischief. I do find probable cause, and I will hear from the parties.
Your Honor, I'm going to be requesting that, Your Honor set a $5,000 bond on this burglary. Mr. Catania, now this will be his 5th open burglary case. Every single one involves breaking into laundry rooms at various condominiums. When he appeared before Judge, I believe it was Judge Powell, on the 31st, on the Newburgh dwelling, she set a $20,000 bond plus a GPS monitor. His bonds on his other open cases have all been surrendered.
He's not gonna be able to make that $20,000 bond based on conversations he's had with our office at prior magistrate hearings. So, is that right, Michael? You're not gonna be able to make that $20,000 bond?
No, is there any way I can be on pre-trial? Because right now I've been trying to help my mom. I can't work. I've been fighting for disability right now.
I'd ask the court to consider pretrial release, Judge. I know he just doesn't have any money.
All right, I'm not gonna do that based on the fact that he was already out on multiple other cases involving the very same charges, just in different locations. I'm not going to do that. I will impose a $5,000 bond on count 7.
Is there any way they could lower the bond on the $20,000 one?
No, Mr. Catania, that's not in front of me today. That'll have to be handled before your division judge. There's also going to be, I'm not sure if there's already a no return on this, but I'm going to impose a no return if there's not one. Joseph Petrie. Do you know where Mr. Petrie is? All right, good morning, Mr. Petrie. You're before the court on ad charges. Count 4 is a charge for grand theft. Count 5 is false owner information for pawn items less than $300. Count 6, stealing and stolen property. Count 7, false owner information for pawn items less than $300. And count 8 is for dealing in stolen property. I do find probable cause for these charges, and I will hear from the parties.
Your Honor may recall Mr. Petrie appeared before you yesterday afternoon for a second look.
Yes.
The burglary at the parking garage. This is just ad charges connected to the stolen property from the garage. Your Honor had released him to pretrial with a GPS monitor on the charges from yesterday.
And Judge, that is correct. Before he was on the second look, I believe he had a monetary bond and he couldn't afford it, and that's why he was still in custody. I do understand these are ad charges. If he's going to be released under supervision, he'll be supervised. I'm asking that the court consider releasing him under supervision on these cases. Just to remind the court a little bit about Mr. Petrie. He's been here for 35 years. He's 49 years old. He lives in Deerfield Beach. His wife, the only person that could possibly help him out, is not in a financial position to post his bond or help him out because, from what he advised me, she does alterations, but business is slow. He works. He has a job waiting for him when he gets out. He's a barber at Royal Cuts. He just got that job about 3 months ago. But, Judge, he can't afford any sort of monetary bond, so that's why he's asking to be released under supervision on these nonviolent offenses.
Haven't been in trouble in 10 years also, Judge.
All right, thank you, Mr. Petrie. All right, so yesterday on the other charges, I ordered him to pretrial with a GPS monitor? Okay, all right, I'll do the same thing on these charges as well. Anthony Piticelli.
How you doing, Your Honor?
All right, good morning, Mr. Piticelli. You're before the court on 2 add charges. Count 31 is burglary, unoccupied conveyance, unarmed, and count 32 is for first-degree petty theft. I do find probable cause, and I'll hear from the parties.
Judge, my understanding, Mr. Pizzicelli has been in custody, I believe, for 6 days. He was given a monetary component to a bond, and he was released, I believe, on level 1 as well. Judge, what I'm going to be asking for is, considering he's going to be on level 1 pretrial, I'm going to ask if the court would consider on count 31 the third-degree felony, if the court could release him ROR to level 1 pretrial.
Your Honor, I can't speak to what was argued over the weekend when Mr. Piticelli appeared before Judge Allspector. All I know is he was, before these counts, he was arrested on 17 burglary conveyances. Why most of them were ROR, I have no idea, but it's very concerning. 1 burglary dwelling and now 18 burglary conveyances. I'm requesting that a $2,500 bond be set on count 31.
Is there a monetary bond set on the other charges?
She said a $1,000 bond on 1 count of grand theft, a $1,000 bond on another count of grand theft, a $2,000 bond on a burglary of an occupied dwelling, and a $1,000 bond on a grand theft. And as Mr. Romero mentioned, also pretrial release level 1.
A $2,000 bond on count 31, and if he bonds, then I'm going to impose the same conditions of level 1 pretrial. Okay, Julio Mendoza Diaz.
He's here, ma'am.
All right. Good morning, Mr. Diaz. You're before the court on count 1, burglary of an unoccupied conveyance unarmed. Count 2, burglary of an unoccupied conveyance unarmed. And count 3 is second-degree petty theft, first offense. I find probable cause, and I will hear from the parties.
Seeing no history, Your Honor, I'd be requesting a $1,000 bond on count 1, $1,000 bond on count 2, no return, no contact.
Judge, normally a $2,000 bond would be reasonable, but unfortunately, Mr. Mendoza and his family are going through an economic hardship right now, as you heard. He has no prior contact with the criminal justice system. He's been here almost his whole life. He went to school here, middle school, high school. He's 29 years old. He's the sole financial provider of his family right now. He's been working for the same landscaping company for the past 6 months. He gets paid about $300 a week. He lives with his fiance, and they have 4 kids. Right now, they've been staying at a local hotel for the past 2 months. Right now, from what he advised me, I believe the hotel's paid up until today. He doesn't know how his fiance is going to try and make some sort of living arrangements for his children and himself and her. But whatever financial resources they have is going to go towards that, to paying some sort of accommodations to stay at for the next week or so. So, Judge, considering he has no prior contact, he's a registered voter here in Brown County, strong ties, I'm asking for the court to consider releasing him under pretrial release on this nonviolent offense.
All right, based on the fact that he has no priors, I will ROR him on all 3 counts to pretrial release. And as the state has requested, no return, no victim contact. Mr. Diaz, I'm not sure that you know the victims in this case, but if you do, understand that no victim contact means no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes, ma'am.
Okay, and Mr. Diaz, since you are being released to pretrial, your attorney is handing you the information, that paperwork right there. You have to report to pretrial within 24 hours. If you fail to do that, then a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
All right.
Your Honor, only
Yes.
other thing, since apparently the clerk's office is going to be unable to send him court notice,
Yeah.
you could just advise Mr. Mendoza Diaz about his responsibilities.
Yes, thank you. All right, Mr. Diaz, additionally, as your attorney has stated to me that you're working on finding out what your living situation is right now, there's not going to be a permanent address for the clerks to send you notices for your future court dates. That's all right. Because of that, it's going to be your responsibility to follow up with your attorneys and the clerk's office to know any future court dates that you need to be present at. If you miss those court dates, then a capias can be issued and you'll end up right back here. Do you understand that?
Yes, ma'am.
All right, thank you.
The location, it's 315 North Riverside Drive in Pompano. Yes. So,
All right, next up is Enel Diamond.
Yes, Your Honor.
All right, good morning, Mr. Diamond.
Good morning.
You are before the court on count 1, driving while license suspended, second offense. Count 2 is an out-of-county felony hold with a no bond, that is not for magistrate. Count 3 is for unlawful speed, that is not for magistrate. Count 4 is for an out-of-county felony hold with no bond, that is not for magistrate. And counts 5 and 6 are also they are both for felony probation violations with no bond. I find probable cause, and I will hear from the parties should they wish to make any argument.
Judge, my understanding is the probation no bond hold is out of Dade County. He's on probation for a felony offense.
Yes.
I spoke to Mr. Diamond. It would not be to his benefit to resolve the matter here today because obviously that would be probably one of the allegations of his violating probation. So having said that, Judge, on the misdemeanor driving charge here in Broward, I'm asking for the court to consider an ROR so that he can deal with his felony probation case in Dade.
I don't have an objection to that as long as Mr. Diamond understands that if he's still in Dade County when his next court appearance is set on the DWLS, that he's going to have a capias issued.
I'm aware of that, Judge.
All right, so Mr. Diamond, I'm going to ROR you on count 1, so you'll be going to Dade. As the state just stated, since you're being ROR on this case, it doesn't mean that's the end of the case. So it's going to be your responsibility to follow up with the attorneys in the clerk's office to know any future court dates that you need to be present for. So you do understand that, correct?
Yes, Judge.
All right. Thank you. Evans Pierre.
Here, present, Judge.
All right, good morning, Mr. Pierre. You're before the court on count 1, driving while license suspended or revoked. Count 2 is a felony probation violation with a no bond hold. Count 3 is for unlawful speed and is not for magistrate. And count 4 is failure to wear a safety belt, and that is not for magistrate. I do find probable cause, and I will hear from the parties should they wish to make any argument as to count 1.
Judge, nothing from the defense considering it as a no bond hold.
All right. Okay, in light of that, I'm going to leave the standard bond in place on count 1. And Mr. Pierre, you're going to have a hearing before your division judge tomorrow morning. Fran Shun Skipper.
One moment, Judge.
I believe this. Yeah. All right, good morning, Mr. Skipper. All right, Mr. Skipper, you're before the court on count 1, delivering cocaine within 1,000 feet of a convenience business, and count 2 is possession of cocaine. I do find probable cause, and I will hear from the parties.
Your Honor, I would ask that the court keep the bonds in place, considering that count 1 is a first-degree felony. Additionally, Mr. Skipper, in 2017, after violating probation, was sentenced to 15 months state prison on a possession of PVP and a 2016 grand theft auto. He was released from state prison August 29th of 2018. Additionally, in 2015, another possession of PVP, 2 separate possessions of PVP. On one of them, he violated probation, sentenced to 15 months state prison. Another possession of PVP, 2015. Possession of cocaine, 2013. Possession of cocaine, 2013. Another in 09. Another in 08. Nothing further, Judge.
Mr. Skipper's not going to be able to afford the $8,500 standard bond, which is currently in place. We're going to be asking for a bond reduction specifically on count 1 from $7,500 to $3,000. As you heard, Mr. Skipper does have a record, but it's no recent arrests. He's 33 years old. Right now he's unemployed. He advised me he's looking for work. Right now he lives with his girlfriend. She's the sole financial provider of the household. They live in Pompano Beach. Their monthly rent is approximately $700 a month, and she's been working at Pizza Hut for the past year. Mr. Skipper says that that's the person that's going to be helping to post his monetary bond, but she's not going to be able to quite afford the $85,000. That's why we're asking for $3,000 on count 1, so a total bond of $4,000 on Mr. Skipper's behalf.
All right, I'm going to reduce the bond on count 1 to $4,000, and count 2, the standard bond will remain. Thank you. Daryl Delhome.
North Broward, Your Honor.
Thank you.
Your Honor, the charge that was booked is not correct. According to the capias, it's fleeing or eluding a law enforcement officer, which is a third-degree felony.
Okay, so what I have on here is fleeing or eluding law enforcement at high speed. So you're saying it's just supposed to be fleeing or eluding law enforcement?
Yes.
All right. So on my paper here, can I just cross that out, or is that going to be fine for processing purposes? Okay. All right. All right. So Mr. Delhome, you're before the court on 1 count of fleeing or eluding law enforcement. Count 2 is driving while license is suspended, first offense, and count 3 is reckless driving, first offense. I do find probable cause, and I will hear from the parties as to bond.
Judge, I'm going to ask the court to consider pretrial release for Mr. Delhome. He's been a resident of South Florida for 20 years. He has a job as a vet tech. He works for a company as a moving assistant. Is that right, sir?
Yes, ma'am. Yes, sir. Yes, sir.
And he's had that job for the last 2.5 years. He has had contact with the criminal justice system before. Unfortunately, he is not in a position to post a monetary bond at this time.
Under the state is opposing pretrial. I don't believe he's a good candidate. One, just based on the nature of this offense, he was served with this. This had to be a non-custody because he fled from law enforcement. They weren't able to apprehend him, noting he behind a car crash. He was forcing other cars to move out of the way so he could get away from the scene, driving 50 feet in the wrong direction at a high rate of speed. I would also note he's got a pending DWLS, DWLS. Matter of fact, he was appearing before Judge Hurley when it was brought to Judge Hurley's attention about this non-custody warrant, and that's when he was taken into custody. While some of his other priors are dated, they are significant. 1998, armed burglary of a dwelling and aggravated assault with a violation of probation. He was sentenced to 70 months in state prison. Also, in the early 90s, grand theft auto, burglary of a dwelling, burglary of a structure. He was sentenced to state prison on those as well. His most recent release from state prison was in 2011. I'm sorry, Your Honor. My recommendation would be a $2,500 bond.
Which I don't believe he's going to be able to afford, Your Honor.
All right, based on the nature of the allegations that are included in the probable cause affidavit, as well as the fact that he was taken into custody while before Judge Hurley on another pending case, which is also related to driving charge, I'm going to impose a $2,000 bond on count 1, and I'll leave the standard bonds in place on counts 2 and 3. Thank you. Jordan Santiago?
Your Honor, that traffic violation was for the same offense. That's what it was. They just, for some reason, I ended up over here because I never had a traffic offense. That was for the same offense here that I'm here for.
Okay, let me just confirm. The driving while license suspended charges in this case, is that the same case that he's in front of Judge Hurley on, or is that a separate case?
Then I will be charged 2 times for the same charge.
Okay, all right, hang on, Mr. Delholm. I'm just going to confirm it.
Yes, ma'am.
It would appear so, Your Honor, but we'll take care of the DWLS that's charged on the felony at his arraignment.
Then, Mr. Delholm, that issue is going to be addressed before your division judge at your arraignment hearing. So the state is aware of it.
Is it possible, Judge, that you could lower that $2,500 bond so I could go to work? I need to go to work, Your Honor.
Mr. Delholm, I've already lowered it to $2,000, okay? So you can discuss that further with your attorney.
Okay, thank you, ma'am.
Thank you. All right, Jordan Santiago? Thank you. All right, good morning, Mr. Santiago.
Good morning.
Here before the court on 1 count of tampering with an electronic monitoring device, and count 2 is a felony probation violation with a no bond hold. I do find probable cause, and I will hear from the parties as to count 1.
Nothing from the state.
Nothing from the defense.
All right, in light of that, I'm going to leave the standard bond in place. And Mr. Santiago, you have a hearing before your division judge tomorrow morning. Reuben Clark?
North Broward, Your Honor.
Thank you. All right, good morning, Mr. Clark.
Good morning.
You're before the court on 1 count of burglary of an unoccupied dwelling unarmed. Count 2 is trespassing on property, not a structure or conveyance. I do find probable cause, and I will hear from the parties.
Your Honor, state would be it actually would appear that this is an attempt.
Yes.
Yes, I did see that.
And I see no history. That being said, though, I am concerned that he attempted, according to the allegations, attempted to break into this individual's home while she was present. I'm going to be requesting a $7,500 bond, no victim contact, no return.
That's going to be well beyond Mr. Clark's means, Judge. He grew up here in Florida. He can stay with his mom. As the state noticed, he has absolutely no prior contact with the criminal justice system. He has a job cleaning pools. Unfortunately, he does not have the financial wherewithal to post that kind of a bond, and I don't believe that his mother has that kind of money either. in light of the fact that this is an attempt, and in light of the fact that he has strong ties to the community and no prior history, I would ask the court to consider pretrial release for Mr. Clark.
All right. In light of the fact that Mr. Clark has no prior history, I will ROR him to pretrial. There's going to be a no return order to this location as well as a no victim contact order. Mr. Clark, no victim contact. I don't know if you know these victims, but no victim contact means no phone calls, no text messages, no third party contact, no social media. Do you understand that?
Yes, ma'am.
All right, there's also going to be a no return order in place. That means no going back to this location. Do you understand that?
Yes, ma'am.
All right, since you're going to be released to pretrial, you'll be getting some information on that. You have to report to pretrial within 24 hours. If you fail to do that, then a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
All right, thank you. Ronald Shines.
Yes, ma'am.
All right, good morning, Mr. Shines.
Good morning.
All right, Mr. Shines, you're before the court on 3 counts, each are the same, of burglary of an unoccupied conveyance unarmed. I do find probable cause.
I believe there are attempts, Judge.
This is, yes, I was just about to say, there are attempts though, so this is gonna be probable cause for attempted burglary of an unoccupied conveyance unarmed. I'm gonna write attempted on here and just put an indication that it is for each of the 3 counts. I'll hear from the parties.
Your Honor, I'm going to be requesting a $1,500 bond on each count, noting I believe it's aggravating that this offense involved more than one vehicle. He was arrested in Broward in 2018 for failing to appear in court. He has priors outside of the state of North Carolina. Sale, delivery of counterfeit controlled substance, 03. It's like multiple cases involving sale, delivery of controlled substances. Nothing further, Judge.
Judge, in speaking with Mr. Shines, he's been a resident here of Florida for the last 7 years. He stays with roommates. He's been staying in the same location for a year. He just started a job as a veterinary technician, and it appears as though a lot of his priors are somewhat remote in time. But he is not going to be able to post any kind of a monetary bond, so I would ask the court to consider pretrial release for Mr. Shines.
I will ROR Mr. Shines to pretrial. Mr. Shines, before you are released, you're going to be getting some information about pretrial services. You must report to them within 24 hours. If you fail to do that, then a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
All right.
All right, good luck, Mr. Shines.
Thank you very much, sir.
Ardell McIntyre. Thank you. All right, good morning, Mr. McIntyre.
Good morning, ma'am.
You are, I'm sorry. Yes. What's the correction? Count 7 and 8. I just cross that out and indicate that on here? Is there another correction?
It's not the correction. The correction is that there's a bond. Gotcha. Well, they also corrected that too.
Is there an additional? Which one?
No, the corrected.
Okay.
Well, on the correction, it's no bond on both. On the corrected sheet, it's no bond on both.
Corrected sheet that you just handed me shows that each of the misdemeanor violations of probation have no bonds on them, but on the order, I have that count 7 has no bond and count 8 has a $1,000 bond. So do they each have no bonds or does one have a bond? Yes. Okay, that's what I have on my order, so that is correct. Alright, so I'm gonna read through these and you guys tell me if there's any more corrections, okay? I wanna make sure you have this right for Mr. McIntyre. Alright, Mr. McIntyre, you're before the court on count 1, grand theft of cargo with a $3,500 bond. Count 2, fleeing or eluding law enforcement at a high speed. I believe that is a capias with, okay. Count 3 is for resisting an officer obstructing without violence. That currently has a $100 bond on it. Count 4, driving while license is suspended, first offense, currently has a $100 bond on it. Count 5 is grand theft. That has a $1,000 bond on it and is not for magistrate. Count 6 is a traffic capias with a $500 bond on it. Count 7 is a misdemeanor violation of probation with a no bond. And count 7 is a misdemeanor violation of probation with a $1,000 bond. Is that all that correct? Okay, so I'm gonna cross that out as well. Right, and I will hear from, I do find probable cause and I'll hear from the parties.
Judge, and speaking, Mr. McIntyre, he's 36 years old, been here his whole life. He's working. He works for a company which basically they load and unload containers. He's been working for them for the past 5 years. Now he lives in Fort Lauderdale with his grandmother. She's on a fixed income, gets Social Security. That's the person that's going to help post his monetary bond. What I'm going to be asking the court to concentrate on is on the not in custody capiases. They're 2016 offenses. Specifically, I'm going to be asking for the court on count 2 to set a $1,000 bond on count 2. And I'm going to be asking on the misdemeanors associated with that 2016 case, the count 3 and count 4, $100 bond each for the court to consider an ROR on those 2 counts only. So that's our only request from the defense at this time, Judge, considering he has also no bond hold on 7 and 8.
The state is going to be requesting a $5,000 bond on count 2. That is a second-degree felony. My concern is his future appearance in court. Based on the nature of the offense, when confronted by law enforcement, he fled. Law enforcement was unable to apprehend him. He's got a capias on another traffic case on count 6, and all this was being done while he was on probation, Your Honor. He also has a warrant out of Dade County for failure to appear on a DWLS, and he has a $5,000 warrant on that case. I would also note these charges, it's not like these cases happened then and they weren't filed until now. These charges were filed in 2016. Law enforcement has been unable to locate Mr. McIntyre until now, when they only came into contact with him based on arresting him on a new law offense. That's why I think the GPS monitor is appropriate and necessary in this case, because pretrial will obviously have to verify an address, and then pretrial will be able to keep track of where he is located. $5,000, the same as his warrant out of Dade.
Just so that you know, I don't have that Dade warrant listed on this.
Your Honor, I think it's Dade County pickup only, so you'd have to get arrested there. I'm just bringing it up as another example of failing to appear.
2, I'm going to impose a $3,500 bond. On counts 3 and 4, those will each be an ROR. Remain in place. And if Mr. McIntyre does bond, he will be released to pretrial with GPS monitoring level 2.
That's what I'd be requesting. Yes.
Okay. All right, thank you. Next up is going to be Torvis Skinner. All right, good morning.
It's still.
This is still Mr. McIntyre.
Oh, I'm sorry.
Yes, no, that's all right. Okay, so Torvis Skinner will be up next.
He's here, President.
All right, thank you. Good morning, Mr. Skinner. You're before the court on 1 count of robbery by sudden snatching without a firearm or weapon. Counts 2 and 3 are each for touch or strike battery. I do find probable cause, and I'll hear from the parties.
Your Honor, the state is going to be requesting a $20,000 bond on count 1, $2,500 bond on counts 2 and 3, pretrial release of the GPS monitor. This is based not only on the allegations of this case. Mr. Skinner is showing that he is unable to stay out of trouble while out of custody. He's unable to follow court orders. Your Honor, Mr. Skinner was just arrested on a little less than a month ago, on December 13th, for battery against the same female victim as in this case. Judge Murphy set a $1,000 bond and ordered him to stay away from this woman. As you can see, based on the allegations, she was minding her own business. He confronted her. She wanted nothing to do with him. It actually makes reference to the previous case where he pushed her face against a glass window. Even when she wanted nothing to do with him, he would not relent. Ended up taking her cell phone. That's not the only case he's out on. He's also out on a battery on a law enforcement officer, resisting without violence, and disorderly conduct. He's also out on a felon in possession of a concealed weapon and resisting without violence. He is resolved to disorderly intoxication, resisting without violence, December of 2018. He's been arrested in 2015 for violating a pretrial release condition, that being a no-contact order from a battery case. That charge was dropped. Your Honor, I believe the bond and release conditions I'm requesting are reasonable and necessary to ensure that not only does Mr. Skinner not commit any new law offenses, but that he will not have any contact and potentially harm for a third time this alleged victim.
Judge, Mr. Skinner is not going to be able to afford that monetary amount the state has suggested. He's basically financially indigent. He's looking for work. He's homeless. He advised me he does have a mailing address where he can receive future court notices. There's a friend of his that lives in West Park that he can use his address to get mail, but there's no way he's going to be able to afford the $20,000.
Well, based on the current charges that are pending against him, as well as the history and the fact that some of these charges actually involve the same alleged victim, it gives me great concern. So in this case, I'm going to impose a $15,000 bond on count 1 and a $2,000 bond on counts 2 and 3. If he bonds out, he will be released to pretrial with the GPS. That'll be level 2. And I'm going to impose a no victim contact order, even though I believe there's probably one already pending with regard to this same victim. So as a reminder to Mr. Skinner, which I'm sure he has heard before from other judges, no victim contact means no phone calls, no text messages, no third-party contact, no social media, no being in the same place at the same time. Mr. Skinner, do you understand that?
Yes, ma'am.
All right. Yes, the 500-foot stay away order will be in place.
And Your Honor, does the no victim contact also include,
That includes the other victim as well, yes.
And
I think there were 2 alleged victims in this case.
yes, Your Honor, and I would just ask for a no return to that chevron.
All right, I have no issue with that. There will be a no return order in place as well. Paul Madden.
Here, ma'am.
All right. Good morning, Mr. Madden.
Good morning, Your Honor.
You are before the court on 1 count of possessing a forged driver's license or ID. Count 2 is a felony violation of probation with a no bond hold. Count 3 is for fraudulent misrepresentation of self or personal identity fraud. Count 4 is false ID given to law enforcement. And count 5 is a felony violation probation with a no bond hold. I do find probable cause, and I will hear from the parties if they wish to make argument.
Nothing from the state.
Nothing from the defense, Judge.
All right, in light of that and the fact that we have 2 no bond holds in place in this case, I'm going to leave the other standard bonds in place. And Mr. Madden, you will have a hearing before your division judge tomorrow morning. Rocky Carter.
He's here, ma'am, Judge.
Thank you.
Good morning, Your Honor.
Good morning, Mr. Carter. All right, Mr. Carter, you're before the court on 1 count of battery on an officer, firefighter, or EMT. I do find probable cause, and I will hear from the parties.
Your Honor, I'm requesting a $1,500 bond.
Judge, we're not that often. Hopefully the state doesn't have objection. I'm going to be asking for a $1,000 bond. His mother is on disability.
That's fine.
He believes that. Thank you.
All right, so the bond is going to be set at $1,000. There's also going to be a no victim contact order. Mr. Carter, no victim contact means no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes, ma'am.
All right, thank you.
A photo order as well, Judge.
All right, that's fine.
What type of order, Hector?
Photo.
Photograph.
Photo? Okay.
All right, and my last one is Richard Barker.
It's medical.
If he's still on loan, Judge.
Okay. All right, so that'll be reset. All right, I believe that concludes our morning docket, so I'll see everyone back here at 1 o'clock for the afternoon.